Freedom of speech and expression. Freedom of speech includes the right to be silent, aptly has it been said that the Bill of Rights that guarantees to an individual the liberty to utter what is in his mind also guarantees to him the liberty not to utter what is not on his mind. The salute is a symbolic manner of communication that conveys its message as clearly as the written or spoken word. As a valid form of expression, it cannot be compelled any more than it can be prohibited. In the face of valid religious objections like those raised in this petition, to impose it on the petitioners is to deny them the right not to speak when their religion bids them to be silent. This coercion of conscience has no place in the free society concept. Continuum of thought, speech, expression, and speech acts. While the present case involves an incident of contempt, the same is akin to a case of libel, for both constitute limitations upon freedom of press or freedom of expression guaranteed by our Constitution, so that what is considered a privilege in one may likewise be considered in the other. The same safeguard should be extended to one whether anchored in freedom of the press or freedom of expression. Therefore, this principle regarding privileged communications can also be invoked in favor of appellant. Purposes of free speech doctrines. No one seeks to deny him that right least at all this court. What respondent seems unaware of is what freedom of speech and of expression, like all constitutional freedoms, is not absolute, and that freedom of expression needs no occasion to be adjusted to and accommodated with the requirements of equally important public interests. One of these fundamental public interests is the maintenance of the integrity and order, the functioning of the administration of justice. There is no antinomy between free expression and integrity of the system of administering justice. Balance between unbridled expression and liberty. Otherwise, the freedom of speech, which is guaranteed with a view of understanding, to strengthening our democratic institutions and promoting the general welfare would be a convenient excuse to engage in the vituperation of individuals for the attainment of private, selfish, and vindictive ends, thereby hampering the operation of the government with administrative investigations of charges preferred without any color or appearance of truth, and with no other probable effect than the harassment of the officer or employee concerned, to the detriment of public service and public order. Types of regulation. Thus, all speech are not treated the same. Some types of speech may be subjected to some regulation by the state under its pervasive police power, in order that it may not be injurious to the equal right of others or those of the community or society. The difference in treatment is expected because the relevant interests of one type of speech, example, political speech, may vary from those of another, example, obscene speech. Distinctions have therefore been made in the treatment, analysis, and evaluation of the permissible scope of restrictions on various categories of speech. We have ruled, for example, that in our jurisdiction, slander or libel, rude and obscene speech, as well as fighting words, are not entitled to constitutional protection and may be penalized. Prior restraint and subsequent punishment, invoking the preferred freedom of the press, which constitutionally protects them from prior restraint or censorship, or subsequent punishment or liability, unless there be a clear and present danger of substantive evil that may be rightfully prevented by law, and disregarding emphatic admonitions by their interrogators to keep silent concerning the interrogation and the risk of possible personal reprisal, they have petitioned of this court for the writ of prohibition with injunction. Bobst versus National Intelligence Board. A burden to show the existence of grave and imminent danger that would justify prior restraint and bar a group of persons from entering the church of their choice for prayer and worship lies on the military or police officials who would so physically restrain them. Indeed, there is no precedent in this time and age where churchgoers whose right of free exercise of their religion is recognized have been physically prevented from entering their church on grounds of national security. On the other hand, it does not lie within the competence nor authority of such officials to demand of churchgoers that they show and establish their sincerity and good faith in invoking the constitutional guaranteed freedom of religious worship and of locomotion as a precondition, as seems to be the thrust of the majority decision. Nor is there any burden on the churchgoer to make a satisfactory showing of a claim deeply rooted in religious conviction before he may worship at the church of his choice, as appears to be the basis of Justice Gutierrez. A concurring opinion for dismissal of the petition, the exercise of such basic and sacred rights would be too tenuous if they were made to depend on snap judgment and disposition of such officials as to one's good faith and his entire. In fact, Article 132 of the revised penal code penalizes public officers and employees who prevent or disturb the ceremonies or manifestations of any religion, while Article 32 of the Civil Code grants an independent cause of action for moral and exemplary damages and for other relief against such officials or employees or private individuals who directly or indirectly obstruct, defeat, violate, or in any manner impede or impair the freedom of religion and freedom of speech of any person. It can, to safeguard other constitutional objections, determine what motion pictures are for general patronage and what may require their either parental guidance or be limited to adults only. What is to abide by the principle that freedom of expression is the rule and restrictions, the exemption. The power to exercise prior restraint is not to be presumed, rather the presumption is against its validity. Gonzalez versus Kalau Katipak. Content-based and content-neutral. It is not enough to determine whether the challenged act constitutes some form of restraint on freedom of speech. A distinction has to be made whether the restraint is first a content-neutral regulation, example, merely concerned with the incidents of the speech, or one that merely controls the time, place, or manner and under well-defined standards, or two, content-based restraint or censorship, example, the restriction is based on the subject matter of the utterance or speech. The cast of the restriction determines the test by which the challenge act is assayed with. With the speech restraint take the form of a content-neutral regulation, only a substantial governmental interest is required for its validity, because regulations of this type are not designed to suppress any particular message. They are not subject to the strictest form of judicial scrutiny, but an intermediate approach somewhere between the mere rationality that is required of any other law and the compelling interest standard applied to content-based restrictions. The test is called intermediate because the court will not merely rubber stamp the validity of a law, but also require that the restrictions be narrowly tailored to promote an important or significant governmental interest that is unrelated to the suppression of expression. Intermediate approaches being formulated in this manner, a governmental regulation is sufficiently justified if it is within the constitutional power of the government, if it furthers an important or substantial governmental interest, if the governmental interest is unrelated to the suppression of free expression, and if the incidental restriction on alleged freedom of speech and expression is no longer than is essential to the furtherance of that interest. On the other hand, a governmental action that restricts freedom of speech or of the press based on content is given the strictest scrutiny in light of its inherent and invasive impact. Only when the challenged act has overcome the clear and present danger rule will it pass constitutional muster, with the government having the burden of overcoming the presumed unconstitutionality. Unless the government can overthrow this presumption, the content-based restraint will be struck down. Incitement and advocacy. One of them, certainly highly prized, of the utmost significance is the right to dissent. One can differ, even object. One can express dissatisfaction with things as they are. There are times when one can not only can but must. Such dissent can take the form of the most critical and the most disparaging remarks. They may give offense to those in authority, to those who wield power and influence. Nevertheless, they are entitled to constitutional protection. Insofar as the content of such dissent is concerned, the limits are hardly discernible. It cannot be confined to trivial matters or to such as are devoid of too much significance. It can reach the heart of things. Such dissent may, for those not so adventurous in the realm of ideas, possess a subversive tinge. Even those who oppose a democratic form of government cannot be silenced. This is true, especially in centers of learning where scholars competent in their line may, as a result of their studies, assert that a future is bleak for the system of government now favored by Western democracies. There may be doubts entertained by some as to the lawfulness of their exercising this right to dissent to the point of advocacy of such a drastic change. Any citizen may do so without fear that thereby he incurs the risk of a penal sanction. That is merely to affirm the truth of this raging declaration from Jefferson. If there be any among us who would wish to dissolve the Union or to change its republican form, let them stand undisturbed as monuments of the safety with which error of opinion may be tolerated, where reason is left free to combat it, as was so well put by the philosopher Sidney Hook. Without holding the right to the expression of heresy at any time and place to be absolute, or even the right to non-heretical speech cannot be absolute, it still seems wise to tolerate the expression even of communists, fascists, and other heresies, lest in outlawing them we include other kinds of heresies and deprive ourselves of the opportunity to acquire possibly sounder ideas than our own. The line is to be drawn, however, where the words amount to an incitement to commit the crime of sedition or rebellion. The stage has been reached to follow the formulation of Cardozo, where the thought merges into action. Thus is loyalty shown to the freedom of speech or press ordained by the Constitution. It does not bar the expression of views affecting presuppositions. It allows, if it does not require as a matter of fact, that unorthodox ideas be freely ventilated and fully heard. Dissent is not disloyalty. Such an approach is reinforced by the well-settled constitutional principle that even though the governmental purposes be legitimate and substantial, they cannot be pursued by means that broadly stifle fundamental personal liberties when the end can be more narrowly achieved. For position of regulation is touchstone in an area so closely related to our most precious freedoms. This is so for a governmental purpose to control or prevent activities constitutionally subject to state regulation may not be achieved by means which sweep unnecessarily broadly and thereby invade the area of protected freedoms. Specificity of regulation and overbreadth doctrine. At the outset, the court rejects petitioners' invocation of the overbreadth doctrine, considering that petitioners have not claimed any transgression of their rights to free speech or any inhibition of free speech-related conduct in Southern Hemisphere Engagement Network (INC) versus Anti-Terrorism Council. This court explained that the application of the overbreadth doctrine is limited to a facial kind of challenge and, owing to the given rationale of a facial challenge, applicable only to free speech cases. In the more recent case of spouses in Bong versus Ochoa Jr., this opined that facial challenges can only be raised on the basis of overbreadth and not on vagueness. Southern Hemisphere Engagement Network (INC) versus Anti-Terrorism Council 632 SCRA 146/2010 demonstrated how vagueness relates to violations of due process rights, whereas facial challenges are raised on the basis of overbreadth and limited to the realm of freedom of expression. That being said, this court finds it improper to undertake an overbreadth analysis in this case, there being no claim to curtailment of free speech. On the contrary, however, this court finds proper to examine the assailed regulations under the strict scrutiny test. Speech regulation in relation to election. The COMELEC has thus been expressly authorized by the Constitution to supervise or regulate the enjoyment or utilization of the franchises or permits for the operation of media of communication and information. The fundamental purpose of such supervision or regulation has been spelled out in the Constitution as the ensuring of equal opportunity, time, and space, and the right to reply, as well as a uniform and reasonable rates of charges for the use of such media facilities in connection with public information campaigns and forums among candidates. Speech regulation in relation to media. From the language of the specific constitutional provision, it would appear that the right to free speech and a free press is not susceptible of any limitation, but the realities of life in a complex society preclude a literal interpretation of the provision prohibiting the passage of a law that would abridge such freedom. For the freedom of expression is not an absolute, nor is it an unbridled license that gives impunity for every possible use of language and prevents the punishment of those who abuse this freedom. Thus, all speech are not treated the same. Some types of speech may be subjected to some regulation by the state under its pervasive police power, in order that it may not be injurious to the equal right of others or those of the community or society. Difference in treatment is expected because the relevant interests of one type of speech, example, political speech, may vary from those of another. Example, obscene speech. Distinction may have therefore been made in the treatment, analysis, and evaluation of the permissible scope of restrictions on various categories of speech. We have ruled, for example, that in our jurisdiction, slander or libel, lewd and obscene speech, as well as fighting words, are not entitled to constitutional protection, may be penalized. Moreover, the techniques of viewing alleged restrictions on speech, overbreadth, vagueness, and so on have been applied differently to each category, either consciously or unconsciously. A study of free speech jurisprudence, whether here or abroad, will reveal that courts have developed different tests as to specific types of categories of speech in concrete situations. Example, subversive speech, obscene speech, the speech of the broadcast media and of the traditional print media, labeled as speech affecting associational rights, speech before hostile audiences, symbolic speech, speech that affects the right to a fair trial, and speech associated with rights of assembly and petition. As articulated in our jurisprudence, we have applied either the dangerous tendency doctrine or clear and present danger test to resolve free speech challenges. More recently, we have concluded that we have generally adhered to the clear and present danger test. Judicial analysis, presumption, and levels and types of scrutiny. Generally, restraints on freedom of speech and expression are evaluated by either or a combination of three tests. Example A, the dangerous tendency doctrine, which permits limitations on speech once a rational connection has been established between the speech restraint and the danger contemplated. The balancing or interests tests, used as a standard when courts need to balance conflicting social values and individual interests, and requires a conscious and detailed consideration of the interplay of interest observable in a given situation of type of situation. And C, the clear and the present danger rule, which rests on the premise that speech may be restrained because there is substantial danger that the speech will likely lead to an evil the government has a right to prevent. This rule requires that the evil consequences sought to be prevented must be substantive, extremely serious, and the degree eminence extremely high. Special topics in free expression cases. It cannot be gainsaid that government action to stifle constitutional liberties guaranteed under the Bill of Rights cannot be preemptive in meeting any and all perceived or potential threats to the life of the nation. Such threats must be actual or at least gravely imminent to warrant government to take proper action. To allow government to preempt the happening of any event would be akin to putting the cart before the horse. In a manner of speaking, state action is proper only if there is a clear and present danger of a substantive evil which the state has a right to prevent. We should bear in mind that in a democracy, constitutional liberties must always be accorded supreme importance in the conduct of daily life. At the heart of these liberties lies freedom of speech and thought, not merely in the propagation of ideas we love, but more importantly in the advocacy of ideas we may oftentimes loathe. This is simply articulated by Justice Louis de Brandeis. Fear of serious injury cannot alone justify suppression of free speech and assembly. It is the function of speech to free men from the bondage of irrational fears. To justify suppression of free speech, there must be a reasonable ground to believe that the danger apprehended is imminent. There must be reasonable ground to believe that the evil to be prevented is a serious one. But even an advocacy of violation, however reprehensible morally, is not a justification for denying free speech where the advocacy falls short of incitement and there is nothing to indicate that advocacy would be immediately acted on. The wide difference between advocacy and incitement, between preparation attempt, between assembly and conspiracy must be borne in mind in order to support a finding of clear and present danger. It must be shown either that immediate serious violence was to be expected or was advocated, or that the past conduct furnished reason to believe that such advocacy was then contemplated. Hate speech. Speech that promotes dialogue on public affairs or airs our grievances and political discontent should thus be protected and encouraged. Barring the words of Justice Brandeis, it is hazardous to discourage thought, hope, and imagination that fear breeds repression, that repression breeds hate, that hate menaces stable government, that the path of safety lies in the opportunity to discuss freely supposed grievances and supposed remedies. Defamation and libel. Defamation, which includes libel and slander, means the offense of incurring a person's character, fame, or reputation through false and malicious statements. Slander is libel committed by oral, spoken means instead of in writing. The term oral defamation or slander is now understood as being defined as the speaking of base and defamatory words which tend to prejudice another in his reputation, office, trade, business, or means of livelihood. Slander is libel committed by oral means instead of in writing. Oral means oral. Sedition and speech in relation to rebellion. The line is to be drawn, however, where the words amount to an incitement to commit the crime of sedition or rebellion. The stage has been reached to follow the formulation of Cardozo, where thought merges into action. Thus is loyalty shown to the freedom of speech or press ordained by the Constitution. It does not bar the expression of views affecting the very life of the state, even if opposed to its fundamental presuppositions. It allows, if it does not acquire, as a matter of fact, that unorthodox ideas be freely ventilated and fully heard. Dissent is not disloyalty. All forms of media, whether print or broadcast, are entitled to the broad protection of the freedom of speech and expression clause. The test for limitations on freedom of expression continues to be clear and present danger rule that words are used in such circumstances and are of such a nature as to create a clear and present danger that they will bring about the substantive evils that the lawmaker has a right to prevent. The clear and present danger test, however, does not lend itself to a simplistic and all-embracing interpretation applicable to all utterances in all forms. The closure of the petitioner's radio station on grounds of national security, without elaboration of the grounds and without hearing, deserves to be condemned in no uncertain terms, for it is manifest that due process was not observed. If there is an idea which should be impressed in the minds of those who wield power, it is that power must be used in a reasonable reasonable manner. Arbitrariness must be eschewed. The main opinion, that of Justice T. Hankey in the case of Ang Tibay versus Court of Industrial Relations, should be made required reading materials for public officials who huff and puff with power, making themselves not merely obnoxious but dangerous. Ang Tibay versus Court of Industrial Relations. Obscenity or pornography. Whether the tendency of the matter charge of obscene is to deprave or corrupt those whose minds are open to such immoral influences and to whose hands a publication or other article charged as being obscene may fall in the test determining the existence of obscenity. Commercial speech. To prohibit the transmission of unsolicited ads would deny a person the right to read his emails, even unsolicited commercial ads addressed to him. Commercial speech is a separate category of speech which is not accorded the same level of protection as that given to other constitutionally guaranteed forms of expression, but is nonetheless entitled to protection. The state cannot rob him of this right without violating the constitutionally guaranteed freedom of expression, and solicited advertisements are legitimate forms of expression. National emergencies. Petitioner Cacho Olivares et al. contends that the term emergency under Section 17, Articles Article 12 refers to tsunami, typhoon, hurricane, and similar occurrences. It is a limited view of emergency. Emergency as a generic term connotes the existence of condition suddenly intensifying the degree of existing danger to life or well-being beyond that which is accepted as normal. Implicit in these definitions are the elements of intensity, variety, and perception. Emergencies as perceived by legislature or executive in the United States since 1933 have been occasioned by a wide range of situations classifiable under three principal heads: economic, natural disaster, and national security. Emergency, as contemplated in our Constitution, is of the same breath. Maybe include rebellion, economic crisis, pestilence or epidemic, typhoon, flood, or other similar catastrophe of nationwide proportions or effect. Speech of public officers. The exercise by this court of the power of judicial inquiry is limited to the determination of actual cases and controversies. An actual case or controversy means an existing conflict that is appropriate or ripe for judicial determination, one that is not conjectural or anticipatory. Otherwise, the decision of the court will amount to an advisory opinion. The power does not extend to hypothetical questions, since any attempt at abstraction could only lead to dialectics and barren legal questions and to sterile conclusions unrelated to actualities. Neither will the court determine a moot question in a case in which no practical relief can be granted. Indeed, it is unnecessary to indulge in academic discussion of a case presenting a moot question, as a judgment thereon cannot have any practical legal effect or in the nature of things cannot be enforced.